Ms. Kappelman,
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Under Sheriff Google. However, at this point in time, this does not invoke the court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
Not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the undersheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules.
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you.
Good morning, everybody. I just got here, so I'm at a little bit of a disadvantage, but it sounds as though the defense has a witness, maybe a jail employee.
Whatever happened after we spoke with the officer yesterday afternoon.
Okay.
Even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. And Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Adelson's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defendants?
No, sir.
An examination for under Sheriff Google by the defense or stairs.
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that information. After discussions amongst Mr. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right, as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as part of the case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, if they have chosen not to speak with you, you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
During the lunch break, that would be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Please bring in the jurors.
And Your Honor, I know that 3 of the witnesses are here. Mr. Scalzo's flight does not arrive until a little after
10 o'clock or so.
Yes, sir.
Well, there's always something in this case, isn't there? And the question,
Ms. Koppelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
and the question is, why at the last minute? Which is what I think the judge's question is, and I agree with him entirely. You know, you find this on TV, you know, that they proceed and then all of a sudden a witness shows up and it changes the whole case. But that's not the way it's supposed to happen in real life. And I heard 3 names. If someone in the chat can help me, if you heard the last one, I heard Linda Bailey, Sarah Newhouse, and Marisol Descalzo, but there was a Chris someone. Is that Chris Corbett?
In the courtroom.
I don't know. So help, if someone can help who the fourth one is. And I will try to keep looking while this is going on. The other,
Jury, everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. Defense will call Kristen Adamson.
there we go, Kristen Adamson. I believe Kristen Adamson is Wendy's, the last lawyer she had in the custody, that ongoing dispute after the divorce. Linda Bailey is listed as an expert. Sarah Newhouse is Tallahassee Police Department. And Descalzo, Marisol Descalzo, was Donna's lawyer at the time that she was arrested. She apparently will be able to testify that Donna was told, or she told Donna, that there was no arrest warrant and Donna was free to leave the country the night of or the week after Charlie was convicted. It'll be interesting to see what Kristen Adamson testifies, because as I recall, the defense made a large effort to
Please raise your right
get
hand.
information from that post-divorce
You
hearing.
swear or
as we
affirm the
open it up.
testimony we will give today will be the truth?
I do.
You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Addison, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the executive council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendy Adelson?
I did represent Wendy Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else. So that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Okay. Did you have that conversation with Wendy Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendy Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school. Children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten court approval for one with a client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendy.
I did.
Was she aware that the chances of success were low?
Yes. I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons. But including the fact that her parents were down there, that Professor Markell had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on that financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow. So you're entitled to the growth on it too, as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court, at least.
Now, I want to back up a little bit. What happened with Wendy Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that. And then at the end of our testimony, the judge asked to speak to counsel, which happens a lot. And she took counsel out. It was me and Professor Markell's lawyer. And she told us she understood why Ms. Adelson wanted to move. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markell, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that. And then Wendy's parents were there. And I actually spoke to Wendy and her parents. And then she went and spoke to her parents again, I think, if I can remember. It was a long time ago. But I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markell's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013.
Yes.
And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendy Adelson to offer Mr. Markell any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time. But we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
before we had a court trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion. And then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose, like fraud or overreaching or something like that. Then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore. And Professor Markell is not with us anymore. So a lot of people in that mediation are gone. And Ms. Adelson has waived confidentiality.
You can do the punch, Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last minute little dust up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markell and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account in all its different permutations was listed in the marital settlement agreement. And Professor Markell had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
So based on what you've discussed, Mr. Markell was aware of the non-marital status of that portion of Wendy Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendy invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendy Gets Her Groove Back. And I had several friends I knew of Wendy's that were there as well. And it was just sort of a Wendy's in a good place. Come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
Okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markell pay Wendy and yourself certain sums?
So according to the marital settlement agreement, Professor Markell kept the house. So he was supposed to pay Wendy for her part of the house. And all the other assets were divided equally so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendy did. And it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendy did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
I think that's right.
Did Mr. Markell pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendy, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markell was going to pay.
Did he pay?
He did not.
What did Wendy ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier. People will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money. And I asked for a court hearing on all of that.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Did that prompt Mr. Markell to pay?
No, it did not.
What happened?
So then Mr. Markell hired a new lawyer. And his new lawyer filed a responsive pleading to that my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
So you filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that is not a proper defense for not paying the money. Professor Markell, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on and Wendy and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached, and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
In the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least 1 or 2 more pleadings that did that.
And before we get to the final one, you advised Ms. Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response. And I told Wendy that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markell and his attorney were attempting to depose Ms. Adelson.
So what happened was, I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing. The judge read all of the pleadings, and she said that she was very unhappy with Professor Markell's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markell file an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting. And it was that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to, that they weren't allowed to go to be present at the same birthday parties, that if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't, I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids. And I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals. But it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markell that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No, it's not possible. And I told Wendy that.
Okay. Now, as Professor Markell continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that, now, back up, had you been able prior to withdrawing to schedule the hearing on your enforcement motion as well as Mr. Markell's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markell had to change counsel again as well?
I did not know that.
Okay. Were you aware that as Mr. Markell is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendy.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even after the even afterwards. they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor.
Excuse me, this testimony probably partly explains why Georgia didn't go into any of the financial issues.
Nothing further.
Cross-examination.
So is this their last witness?
No, God, Tim, well, I'll fill you in when we have a moment.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings. How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT meetings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this. That's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, but
Right.
And I thought she had a good shot or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion. And I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay. Even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right. And at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that that's probably why I had them sit outside, is because they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
right.
you were done calling witnesses.
Correct. So that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why they were in the hallway. Yeah.
Okay. Not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendy, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened, what was going on. And, you know, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendy went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforced it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue. And that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, that it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then
could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. And it would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money. And then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien, worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license possibly? If he's held in contempt of court, or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt. I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred. I mean,
Okay.
that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine. And then all of a sudden he decided not to pay the rest. And I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay. Thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is
And
when he did that.
Was that personal attacks on both Wendy Adelson and you?
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes,
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendy should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not, we've had a few people get murdered, and I've had a few suicides, but it's rare, and I remember all of them.
Right. But not contentious.
Sometimes, I don't know with the suicides, I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor.
Unbelievable.
Mm-hmm. Where do you hear what happened before this started if you want to hear about unbelievable?
So they haven't decided if Donna's gonna testify?
We didn't even get to that.
Okay,
We need more than a little break.
okay.
And first witness.
You may.
Ms. Adamson, I'm going to approach and show you some, I'm sorry. States demonstrative A, I think it's going to 1, page 441 of the demonstrative. And then I'm holding 454, if you can hold that,
Sure.
please.
Okay.
Is that
Okay.
the March 26, 2014 pleading that Mr. Markell filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markell was asking that my client's unsupervised time with the children not interfere with his right of first refusal.
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adamson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendy Adelson and yourself.
Correct.
Okay. Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markell not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling to you.
As far as I know,
You don't know what she said privately, do you?
I do not.
How does that help?
Concerning
I'm not sure any of this helps.
Wendy Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts. And then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
We'll retain her, but she's free to go about her business.
Thank you.
You may step down.
Well, I see people in the chat.
Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to
Linda was sitting in the courtroom.
break.
Is she? Did they do
Yeah.
it again?
You can take a break. or
She's
you
sitting in the courtroom.
Raise your
I
hand.
just saw her.
In the courtroom or in the hallway? Jim?
No, she's sitting in the courtroom.
Well, somebody should say something.
Very rude. Resume at 10:05.
Yeah, I just saw her in the courtroom when the.
Well, I saw a picture that somebody sent that had her, I believe, in the hallway, but not in the courtroom.
No, they just panned and I saw Linda sitting in the back row.
Okay, well, somebody should let the state know, or the judge know, or somebody know.
So what did I miss?
Well, I got here a little late myself, but when
Can you
I
see
went
it?
on,
Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. We'll try to start again at 10:05.
Thank you, Your Honor.
when I got on, they were discussing witnesses for the day.
Yeah.
And one thing they decided, if I can find where I have it, because I wrote them down, they do have a number of witnesses this morning. It's Bailey, it's Marisol, the Calzo,
Yeah.
Linda Bailey. I'm missing somebody because I don't have my page here, but there's another. It's when I find my page, I'll give you the other one. They couldn't say who's going to be testifying this afternoon, but what we started with was the defense wanting the judge to subpoena jail officials because they want to interview a guard at the jail who they claimed, after discussion with her superior, was advised not to cooperate and talk to the defense. So they then wanted the judge to issue subpoena. The judge said, I've got only so much authority here. And they said, well, it was their belief that this witness was told, or this guard was told not to cooperate. So then the judge put on under oath the captain, who said, all I know about it is that the intermediate supervisor had said that this guard had come to him and said she thought that the defense wanted to talk to her and what were her legal rights in all of this. Her name is Franklin. What were her legal rights? They consulted with 3 or 4 lawyers at different levels. One, the lawyer for the jail, but a couple of others. And they advised Franklin, the guard, that if there was no subpoena, she was free to cooperate or not, and it was her decision.
That's a true statement.
Right. And then the defense, and it was Josh, said that he needed the judge's help. And the judge, as you can imagine, was not a happy camper over all of this. And he wondered why this was coming at the last minute again. And they left it that the defense is going to try to send somebody out to subpoena Franklin. They're still going to have to interview her because they haven't talked to her yet. And I don't know where they got the information that she has something relevant to their side of the case. But that's how we started, with the captain being put under oath to say he had no information and he didn't advise Franklin or tell her that as her boss, she was not to talk to the defense.
Now, what did these lawyers say that this guard information has?
Well, they said, and maybe somebody in the chat will say something, when I got on, they weren't talking about what. They just said that there was information and they needed to talk to Franklin. I don't think, but now I'm speculating. But given the way they've done every motion I've heard from the beginning, I don't think they provided any concrete information as to what they expected to get from the witness. But the chat, you heard me just say this, and if I'm wrong because some of you were on earlier, then please correct me. But that's what I am assuming occurred. And this went for quite a while because Josh kept pushing the judge to order a subpoena. And the judge kept saying, I can't interfere. Why didn't you get this done?
Yeah.
So that's
Well-
how we started this morning.
Well, family law is a horrible practice. Most lawyers get hurt or killed in family law cases. It's terrible. And when Kristen was testifying, I just let the right people know that Linda was in the courtroom, and they were wondering too. So we'll see what happens.
Well, the judge, were you there yesterday when the judge told Josh at the end of the day, this better not happen again?
It just happened because I know Linda. I've known her for 25 years. I saw her sitting in the back row. I've known Kristen also.
Well, how can they do this twice?
She was sitting there during, and should know better. She's a lawyer. She knows the rule's been invoked. It just, when I heard Kristen testify and said she doesn't take information from her clients. Oh, but if I get facts.
Yeah.
But she has to rely on facts from a
Of course
client.
she does.
So she has to get information in her pleadings from the
of
client.
course.
She's not. So that's just a false statement, right?
Yeah. Here's the fourth witness, Sarah Newhouse from the Tallahassee Police Department. They're also calling.
I don't know who. I don't. Yeah.
So it's we just heard from Adamson, Bailey, Newhouse, and DeCalso were their morning witnesses, and of course, I don't think they're going to get them all in now. I thought, and there were a lot of people in the chat I know who disagreed. I thought she was effective. I didn't think she sounded biased. They had her qualify as an expert on family law right at the beginning.
Kristen?
Yeah, I think that's
probably true.
Yeah, and I thought that this, I didn't hear her be biased one way or the other. Others may disagree, and she certainly cast the acrimony slightly differently than it had been cast in the past. She was pointing more at Dan Markel, and of course she would because she's on the other side. So I think to that extent, I don't know that she moved the needle very much, but I thought she was an effective witness on the stand. And I thought Josh did a pretty good job with his direct examination of her.
I wonder if the judge is going to preclude Linda from testifying.
Well, we'll have to see.
The court inquires and asks her, were you sitting in the courtroom during Kristen's testimony? And she says yes. I think the court now has the ability to say, this is the second time.
Right.
You're not calling this witness.
Right.
The rule, you need to be responsible for your witnesses.
Right.
And this lawyer, Linda Bailey, is a very good lawyer. She knows the rule was invoked. She shouldn't have been sitting there. And she was listening to Chris. She's going to testify to the same thing that Chris.
Same issue. That's right.
So this is a big difference in the earlier one.
Exactly. And the judge warned them at the end of yesterday, don't do this again. So
I mean, Kristen and Linda are very experienced family law lawyers. They have, and they know what they're doing. And I don't believe either one of them will get on the stand and lie. I don't believe that. I mean, you might disagree with their view of things, but I don't think either one of them would risk their reputation and risk their bar license.
Careers, yeah. No, I agree. And I did think Adamson gave a pretty good picture of the way that the post-divorce proceedings went.
Yeah.
And it was pretty, it sounded accurate to me. I mean, I don't know it, but it certainly was a pretty good picture. So I think to that extent, she was helpful. It's just that this is really what she talked about in terms of how divorce and family law goes. And this wasn't nearly as acrimonious as most is, again, it's in general what's going on, but it doesn't address how Donna in this case felt.
The question is, I guess, is she testifying as an expert? And if she's testifying as an expert, is the court going to allow her? Because experts usually can watch. Now, I don't know if she's a fact witness or an expert witness, Linda. That makes a difference.
Yeah, as I recall, I don't think he ever said, I don't think that Josh ever said, you know, we want her qualified as an expert, or the judge ever said so, but he went through her credentials in the way that you would do them if you were qualifying an expert.
Yeah, you said they let Kristen testify as an expert, right?
You're asking me that?
Yes. Did they let her testify as an expert or as a fact
Unclear.
witness?
She went through all her credentials in the way you would qualify an expert,
But
I'm
okay.
not sure. I didn't hear the judge say he's accepting her as an expert, or Josh asking for her to be.
Okay, that's a big difference.
Yeah.
Because if you're tendered as an expert to give an opinion, you can watch the testimony. If you just have a specialty and you're giving fact witness, but you're not deemed an expert, I don't think she should have been in the courtroom. I think she
But
should have.
we're talking about Bailey now, and Bailey hasn't come up yet, and Kristen was the first witness this morning. I think it was Jared Ross who had a comment before saying, you know, all she's proving is that at the end it was acrimonious, and that's true.
Yeah, the state knows that they saw her in there too, and they thought that they saw her walk in.
Who are you getting that from? You must be getting messages, Tim.
I am.
Don't disclose.
You
don't have to disclose the source.
Yes,
just disclose the information. We'll be curious about the source, but we'll accept if you just give us the information.
Let's see if anything happens.
Well, maybe they're going to try to qualify Bailey as simply an expert witness and not
They
a
might.
witness.
They might. That might solve the problem.
Yeah.
But did they list her as an expert?
Yes.
They listed Linda Bailey as an expert?
I believe that's true. Yes, they've got her Linda Bailey expert address, and then in parentheses, expert in full caps.
Okay, so then
she list.
Okay, so then she can watch then.
Right.
Yeah. Okay. Because I wouldn't think Linda would do that if she didn't know she could be in there.
Right.
So she's going to give her years and years experience, and she's a very good lawyer about the proceedings, law. So yeah, that's fair.
Right. But much to my surprise, and I suspect, Tim, also your surprise, fully half of the witnesses on the defense witness list are going to testify. Particularly if I take off the ones that have testified for the state. I mean, they've pretty much gone down this list.
Yeah, well, it wasn't going to take 4 or 5 days.
No, but still, it's a surprise that they're going through and doing this. Ultimately, though, and it was pretty clear that, Sarah Catherine asked Adamson a question about this. It was pretty clear when she said Donna was very cordial, and she had no firsthand knowledge of Donna being nasty about any of this, that she had no idea what the emails were between Donna and Wendy, nor did she have any idea of the things that Donna was saying about her as the lawyer, not doing her job correctly.
No. Yeah, that may be true, but I can tell you from representing my clients, I can tell you if I know the parents are involved and the issues are coming from the parents and not from the client, because you can get a feel for your client real quickly. And then your client is laid back, and then you get all these monster things, aggressive. It's not coming from the client. And then when you talk to the client, you're like, yeah, this is not coming from him. It's coming from the family. I would have thought that Kristen would have been able to perceive Donna's involvement more than what she testified to.
Yeah. Well, and it may be that some of what Donna gave Wendy, even if Wendy gave Donna the impression that she was sharing with her lawyer, Wendy may not have been sharing it with the lawyer.
That's true.
I mean, this is like having an intermediary again. You don't know what the intermediary was doing with the information from one end.
Whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know I'm going to go over to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony.
Whether she knows Linda Bailey wouldn't do it or not, I think she should ask those questions in front of the jury on the record.
I guess my link worked. My phone link worked. But yeah, the judge has said, the Supreme Court says that remedy of not letting a witness is the most extreme. So he's kind of telling her my hands are tied. But it's again showing that the defense, no one is looking at their witnesses. No, what is that paralegal doing? I don't understand. Where is their investigator? Who is running the show? It's not for prime time.
Well, the first three questions were rhetorical, and the fourth was your just conclusion. So I have nothing to add.
Did you see my article today about?
No, you didn't paste it, and I can't
Yeah.
get. I don't have a subscription to the paper, so I couldn't get it. I was going to ask you about it, but I had a busy night and a really busy morning, which is why I got on a little late. So
Me too. So if the listeners want, if you can get online, the Democrat asked me if I would do the pros and cons of Donna testifying. So I went in and I added a little music, The Gambler with Kenny. I discussed all the pros and cons of Donna testifying or not testifying. And they were really excited about it. I'm curious to see if people read it, what they think. So
please send it to me.
I will.
To look. So you didn't want to use, I did it my way?
No, it was going to be, should I stay or should I go?
Yeah, I know.
And I ended up going, with The Gambler, no one to hold him and no one to fold him.
No one to walk away, no
one to run. And then I added
response to you.
I added in there that Donna had already tried to run, but that didn't work. So now they're going to have to make a decision whether to hold him or fold him.
My response to you was, you can know whether to run and not be able to.
Right.
Yeah. So I think from my perspective, this witness cast Dan in a different light somewhat. But all she did, and I think Jared Ross was right, is to the extent she described all those late filings and the contempt motions, that it really got acrimonious.
Everybody knows it did. I mean, no one's hiding the fact that Dan was not happy, that she wanted to try to leave. And I think that what Kristen said is right. The divorce was amicable, but everything after that was not.
Right.
And I don't like the way she said we didn't have the hearing because I called Jimmy and he was dead. Come on, Kristen. He was murdered. Okay. He was murdered. This wasn't a suicide. He was murdered. That's why. And Charlie, the relative, was convicted, and the mother of your client now is on trial. So show a little empathy.
Yeah. Well, this morning is turning out to be a surprise, to me at least.
Yeah, that's another one. I have to use your cold as ice. I have to use that for my next article.
And so now, how do you think this is going to affect the state's calculation about what to do on rebuttal?
Rebuttal?
You think they'll call
I think they will call Webster.
Webster, sorry. Even though, as I followed it, he was the lawyer right at the end. The lawyer that she talked about throughout the divorce proceedings was not there. And then it sounded as though there was another lawyer before they got to Webster.
Yeah, there was. And
Okay.
remember, Stephen had never done a family law case before he got hired in this case. So I think Dan did try to go after Kristen and for fraud.
Well, one person in the chat is annoyed I said she was credible when she said she handled her sister's divorce when she shouldn't. Well, I guess I'll have to stand by my reaction. Everybody has a different reaction to testimony, and I thought she was credible.
Well, Kristen is very experienced in family law. I can tell you that.
Mhm.
She's been around, and so is Linda. In fact, I can tell you, I refer cases to Linda. Linda's a very good lawyer, very good family lawyer.
And she handled the mediation, I believe, is what they said.
Okay.
Oh, and that was what I was going to say to people in the chat, because Adamson described one of the mediations that they had, and I suspect that everyone is not familiar with how mediation works. The
Right.
lawyers and the client for one side are in one room. The lawyer and the client for the other side, or the adversary, is in a different room. The mediator goes back and forth between the rooms, talks to one side, talks to the other, does not disclose what he or she may have heard when he or she was in room one with, let's say, the plaintiff, and then goes over to the defense, doesn't disclose what the plaintiff said, but attempts to move the needle on the defense side, and will go back and forth. The mediator gets a lot of steps in a day of mediation. So that's what she was describing, and that's the way mediation is handled.
Yeah.
This trial promises to have more lawyers testify. I'm going to have to think about it now than any criminal trial I've ever seen.
Okay. I emailed you the article.
Thank you. I'll read it as soon as there's a break.
Steve read it. He liked it a lot.
Mhm.
And Steve knows a lot about music. Steve is really a smart guy. He
Yeah.
knows movies and music as much as anybody I know.
Mhm.
That's Steve Cohen for the listeners. I don't really think that information that is really helpful to the defense. I don't think it moved the needle in any way.
Yeah, I don't think so
I
either.
think they're just checking the boxes and calling witnesses.
It doesn't, because no matter how accurate she may be about how divorce and family law goes and how it can be acrimonious and how you can get called names and people are angry at each other, and family members may be even more angry and upset because they're not in the room and they're not privy to what the lawyer is telling them. And no matter how much she might say, this one either fell as a run of the norm or for the divorce part was pretty amicable. The issue here is not what happens generally, but the impact on Donna, and then also on Wendy and what they did, not what in general is happening in other cases. And she didn't really, I don't think she made a dent in that part of the case, and that's the part of the case that matters.
I don't know how to put my article link for the listeners, the subscribers. I don't know how to do that.
Well,
I'm
I
not
cannot
technically
help.
savvy.
I'm less so than you.
The one question that I thought that I wish Sarah could have asked Kristen at the end, isn't it true that sometimes grandparents suffer the worst in child custody cases?
Yeah.
And are the most hurt? And she would have to say yes, because if you don't get relocation, you're at the mercy of that parent, whether you're going to see those grandkids again.
Right. I wish that there was a way, and if Wendy is indicted, it will certainly be relevant, but I wish there was a way to get in here where there's all this sympathy about Donna and how invested she was in her grandchildren, how much she wanted a part in their lives. And then what Wendy, and I think Donna also, did to Dan's parents and those grandparents.
Right.
I mean, we're only focusing on one set of grandparents, and every point you make about why they're invested and why they're heartbroken and why, you know, they wanted the kids in near them in Miami it's the same argument you can make on the other side, and it just shows the cruelty.
It's funny how some of these people make comments. They obviously have not seen my last article about the train, where I indicate that I believe that there is sufficient evidence for Wendy to be charged. So hopefully some of these people will not listen to other podcasters, but look at the articles and that's being written in an objective way. I think there is sufficient now for them to go after Wendy.
I the other night, Tim made a list of the pieces of evidence that were there before and the ones that have come out in this trial that could be entered into evidence against Wendy I've always said, I thought you could make a case for beyond a reasonable doubt, but you had to, every inference on each piece of evidence, the jury would have had to run in the direction of guilt. And that made it a tough case. With the extra pieces of evidence, running the inferences towards guilt is much easier.
Yeah. You know, it's not going to be easy. It's going to be harder than the case for Donna, because Donna paid. Donna allegedly drove and dropped the money off. Donna's on code, but you still have sufficient evidence. The question is, does Jack and does Georgia feel comfortable to take that on? And I think it's going to depend on how this verdict comes.
Mm-hmm. And I believe that there's a reasonable chance that we have not seen all the pieces of evidence that they have against Wendy. I don't think they've disclosed them all, even in this trial.
Mm-hmm. I think that's right. And in my article, I talk about the train, how every trial they give more evidence to the future defendant. And that's what they've done in this case. They've introduced quite a bit of evidence against Wendy.
Right.
And one piece that's so damaging is that why would Donna have the license plate and the car and make, and how would the killers know to find him, you know,
right,
without that information? And how would they have known that he was leaving town? How would they have known that?
Right.
They had to get that information from someone in Tallahassee.
And I will add, with regard to the license plate information, that's showing up in the 2014 planner after the divorce, after the relocation is denied. It's showing up in the back, not on a particular calendar day. And it's showing up when Dan is and the children are in Tallahassee and Donna is in Miami. So any claim that she needed the license, I think I mentioned this the other day, the people in the chat had said maybe because he wouldn't be able to drive onto the property without showing the plate number. Doesn't make any sense because he's never going to have his car in Miami where she was. So,
and they hadn't been down. They've been divorced for 2 years.
Yeah.
They weren't ever going to run into each other again.
Certainly not in Miami.
No.
And I wonder, they keep repeating, Tim, and Josh did it again today, that Dan had asked Donna to babysit the boys on occasion after all this was over. And I don't know where that information is coming from. If it's coming from Donna, clearly she's going to have to get on the stand. And from whom else could it come?
Right. So in this article, I sent it to you, Joe. I pose those questions that she has to answer all these questions, and the minefield is so voluminous that you can't really decide. On the other hand, if she testifies, she's giving up sufficiency of the evidence as an appellate remedy, right? And in their Rule 29 motion, they copied the case of Denise Williams, where her murder conviction was overturned. But if she testifies, that remedy is gone because a jury can convict you based on your credibility alone. So that's what the defense is weighing. And what my article said was the way that the defense presented this case in a very uncharacteristic manner is they put character witnesses first. Why did they do that? Because it's a trial balloon. They wanted to see and attack the prisoners if they could fix all the problems without having to call Donna. So they did that, but it failed miserably. So now they have to, at the end of the day, make a decision. We failed in undercutting the government's case. We have to put her on. Is it worth waiving the appeal? And that's what they're going to decide.
Mm-hmm. I thought, we didn't get a chance to talk much about that hour and 10-minute or 15-minute tape in the jail.
Yeah.
Where Drina and Donna are sitting. I thought that helped the prosecution more than it helped the defense.
Joe, and I thought about it last night. Now I know when they said they needed to get their client's permission, I think they had to get the client permission to show her in the jail, being in custody, and wanted her to waive that.
Yeah. And
not make it an ineffective assistance of counsel.
Right. But didn't you think, if you look at the state's explanation here, and it was that Donna and Drina sat, and that Donna wrote out the script for Drina. There is nothing in that tape that undercuts that explanation. In fact, it looked as though Donna was writing the whole time and talking a lot.
Right.
There was nothing that's why I thought it helped the state more than the defense.
I think it did. And it showed how friendly they were and that these inmates would have the ability. And Donna was very friendly. It wasn't like she was off-putting. She's sitting with her, writing down. It's clear. It's clear it shows it could have happened the way the inmate says.
And although Bird was pretty much, her credibility wasn't very strong to start, and they certainly
I'm sure. I didn't see it, but I know her criminal history is really
they
cool.
certainly made dents in it. But on the other hand, I think a juror could look at that and say she wanted something, one thing or another. She either wanted some benefits if she was going to have to sit in jail in prison, or she wanted a deal from the state to get out early. And she started out dealing with Donna, and that was that first the woman investigator who interviewed her. And now she's telling the story that Donna told her to tell. Right. And then she thought more about it and decided, her situation was better if she aligned with the state. And then she told the state what happened.
All right, Joe, I got a client that just showed up, so I'm going to take a break for a few minutes. I'll see you in a little bit.
Hopefully no fireworks while you're gone.
Okay.
Okay, Tim and I were talking, and I apologize to the people in the chat. I did not look in the chat.
This is from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, sir.
Please make your argument.
Judge, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zalman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies, and then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing As to the lay witnesses, page 63, starting lines 11 through 14. As to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses, we were not asking for that.
As to both the context and the discussion that's concerned an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge,
Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes. But the state made no agreement as to anything but an adverse expert as to observation and testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, was the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom and appropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Cappelman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses that are experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Cappelman, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice. But moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Reviewing Earhart, exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
as it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected?
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so a proffer can be taken on this matter. And after that, I will step down, briefly review what I need, and make a ruling.
The issue here is the state agreed that the experts could listen to the testimony of other
Please raise
experts.
your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated.
But Adamson
You may
was.
inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markell divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple of weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markell's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendy Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendy Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendy as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Job well done. An examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No,
preparations?
I think So,
No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
Judge is going to think about it. So what I started to say was an expert witness can sit in on the testimony of another expert, because in part what the expert is going to be doing is not only giving her expert opinion, but can comment on the opinion of another expert. But like any other witness, an expert witness is not entitled to listen to fact witnesses. Kristen Adamson was not qualified as an expert when she testified. In fact, she might have been qualified. She certainly seemed to have the background and credentials, but she wasn't. And so therefore, it was the expert witness Bailey listening to the fact witness Adamson, and that was not permitted. Now, they also talked about a sidebar in which the defense raised the issue that they wanted Bailey to be able to sit in and listen to Adamson. And what appeared to have occurred is there was no direct response from the state with regard to Bailey and Adamson, but a more general response from the state that expert witnesses were entitled to sit in and hear the testimony of other experts, but otherwise were subject to the sequestration order. That was a general response that would include Bailey sitting in on Adamson, but it does not appear that anyone said directly, and that includes Linda Bailey sitting in and listening to Linda Adamson. Is it Linda Adamson? I'm sorry, I don't know her first name. Kristen Adamson, if she's only testifying as a fact witness. What Judge Everett said was his reading of the sidebar transcript supports the state's statement that the state did not consent to Bailey sitting in on Adamson's testimony if Adamson was not qualified as an expert witness. Now what he has to decide is whether the extraordinary remedy of exclusion of this witness' testimony is warranted. And one of the things he's going to have to consider is this will clearly be an issue on appeal. And is it the kind of issue on appeal that could tank a conviction in this case if there were to be a conviction? So that's where we are. Okay, let me see if there are any questions here. I've got a I hope that didn't go to my explanation. But if it did, I really apologize. Give me a more specific question and I will certainly try again. And I will say, I didn't get a question as to, well, gee, why weren't they more specific and precise? When you're doing sidebars, actually, when you're doing any kind of oral argument, it's sometimes difficult to step back and say, did I get a sufficiently precise answer here? When I think that I got an answer that said yes, am I sure I got an answer that said yes? So these things can occur. It's why lawyers, I'm only talking about lawyers here, but it certainly applies to more than lawyers. It's why lawyers have to be so careful to listen and pay attention and keep clear what it is the issue is that's being dealt with. Jose B said, adverse expert, not expert. Well, generally, if you're the prosecution and the expert is testifying on direct for the defense, that witness is considered adverse. It may be that what the witness says is pretty, consistent with what your expert said, but the adverse nature of the expert relates to whose side has called the expert to testify. I'm sorry we can't do a poll here. It would be interesting to ask whether people think, gee, it's worth it to exclude and run the risk of appeal, or whether people feel the case is so solid that it's not worth the risk. I have a question here from Sunny Days 55. What is my opinion of this affecting an appeal? Well, my opinion is if the witness is excluded, it will certainly, without question, be an issue on appeal. And the appellate lawyer on appeal will say, one, the colloquy at sidebar was not sufficiently clear to alert the defense that the state had not consented. And therefore, the defense, in relying on what it thought was consent, was acting reasonably and therefore error to exclude. The second argument would be, even if the defense was unreasonable in understanding the meaning of the colloquy, in other words, in thinking that the state had agreed, this remedy is an extraordinary remedy, and it had the effect of implicating the fair trial right of the defendant. It's an extraordinary remedy. The expert got on the stand and said she had already read the testimony from the last trial. She had read all the exhibits. She had even talked to this witness a week before testifying. So there was not, and she said there was nothing that the witness said that was different from what her understanding was before and would affect her conclusion and her testimony in any way. And therefore, even if it's an error on the part of the defense, the remedy, the extraordinary remedy of exclusion should not apply. And my guess is that that's what Judge Everett is going to decide, that he's not going to apply the extraordinary remedy. Now, part of it depends on whether you think the case is strong enough that the second witness keeping the testimony in won't affect anything very much. And I guess my view is the case is strong enough, but this is really a judgment call on the part of the state in continuing to push for exclusion. And it's a judgment call on the part of the judge as to whether there is such substantial prejudice in not letting this witness testify that it risks the defendant's right to a fair trial. Tangerine said it's a game they're playing. I don't know that it's a game, Tangerine. I think it's really an honest error by both sides as to what was agreed to. And the defense may have been unreasonable in hearing that it was okay when the prosecution said clearly you can sit in on an adverse expert. But I don't think it was a deliberate effort to sabotage. Yeah, Patches said Zellman didn't ask that Adamson be admitted as an expert. No, he didn't. He just had her as a fact witness. And as I said, I think they might have been able to qualify her as an expert. Had they done this, this issue would not be before us, because then it would have been one expert witness sitting in the courtroom to hear the testimony of an adverse expert witness. But that's not what happened. All right, I'm pushing through to some questions. Nurse Kristen wants to know what I would rule. I think I would be really unhappy about doing this, but I think I'd let her testify. And the reason I would be unhappy is rules. You have rules for a reason, and to allow the defense twice to manage to break the same rule just bothers me a lot. And if I were the prosecutor, it would annoy the you-know-what out of me, that we have rules, and if it was the other way around, they certainly would be applied strictly to me. But that when it's the defendant and the defendant's interests, that my right to have the rules followed is not given as much weight and attention. But what I'm sure Judge Everett is doing now is reading some cases And he may actually even be calling another judge that he respects, to talk over with another judge what another judge's view of this particular legal issue is. But I'm sure he's reviewing the case law. And maybe if I were he and it wasn't middle of the day, I think I'd have a bourbon at this point. It's not even lunchtime, and I would be willing to have a bourbon. But of course, then I wouldn't have to go sit on the bench for the afternoon. And this is not an option available to him. He's going to have to wait until after 6. Okay. CJ said, "Is the court being overly conciliatory?" I don't know that I'd say conciliatory, but I would say the court is being extremely careful to protect the defendant's interest to a fair trial. In part because that's his job, and that's what we expect to happen in courtrooms. The defendant's right to a fair trial is honored. That's a bulwark of our society. But in part because there is no question it will be an issue on appeal if this witness's testimony is excluded. And so he's got to worry about that also. So Maverick from India said, "Do I really think Donna will be found guilty?" Now, this is my opinion, but my answer is yes. Okay. Kate 2, Kate Coco 6. Could this go to ineffective assistance of counsel if the judge doesn't allow the witness to testify? It could be part of a general claim on appeal that the defendants did not provide the effective assistance of counsel. This one, though, is a little easier. I have to think about whether the other would be the same way, but this one for sure is easier because the first question, which is, did these lawyers do a reasonably competent job that would be expected of other lawyers? In other words, did they do less than what we would expect from a minimally competent lawyer? And even if the answer is yes or no, they didn't meet the minimum standards, and this is a prime example of why they didn't. The second question is, would the decision at trial be different if the lawyers had been competent? In other words, if they had not had Bailey listen or qualified Adamson until the testimony was heard.
Starting this issue of the testimony of Linda Bailey, court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
I think that's a reasonable result, and it's the safe result.
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand. If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems.
I wonder if there are any of you who disagree with that in the chat, but I do think it's reasonable because I think risking a reversal on appeal for this, given the other evidence in the record, as compared to whether they would get a conviction without Bailey's testimony and they won't get one with, because that's the calculus. I think this is the right ruling.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn.
And I
Do you
think
swear
Georgie
or affirm the testimony you're about to give will be the truth?
I do. Make
take your
the record that Bailey was in the
You may
court.
examine as you're ready.
So this is Linda Bailey. She's a
Morning.
mediator
Can you please introduce yourself to the jury?
and a
My
lawyer.
name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adamson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I during law school and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, et cetera. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay. And do you know what percentage of lawyers in Florida are board certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you. And that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a board Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course, you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many yees. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines. But at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir the witness as to their training or experience.
No, Your Honor.
In objection to her ability to provide an opinion in the fields of marital family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendy, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going. And it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markell. Which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary. But then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markell have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now we're using the term time sharing. We also have during the trial heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer.
Not between parents. The term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markell from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markell from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So in other words, when Wendy initiated the dissolution against Mr. Markell, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 4951.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markell's motion to dismiss the petition for relocation. And then he had filed a motion to enforce life as he would have liked to have seen it. And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then,
in other words, he was asking the court to enforce something that they had agreed on, but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So he would, let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markell's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markell resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markell case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything: temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
as of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
no, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markell's lawyer was trying to depose Wendy about the money he had not paid. But prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah. So, for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally, if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company,
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. That makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendy Adelsen's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, I believe Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markell were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelsen's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markell?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markell's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markell's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markell was drafting these pleadings because they just weren't drafted in a way you would draft them. And they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them. And he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so dollars. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client in the emails you review appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace. I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendy was sent by her mother. Did you see evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, childcare, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markell had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markell get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markell to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markell granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling with Mr. Markell and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markell?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markell ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markell's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later,
It was very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markell were due within 60 days. So that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markell had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did. Okay. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation be dismissed. So
now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markell to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Nothing unusual about
Routine.
that. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it's a few month period, even after these motions had been filed that kind of upped the temperature a little bit. And they were working well. I saw some communications where Mr. Markell was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? An approach with courts. One states demonstrative A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution, and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markell?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markell emailed the parenting coordinator and Wendy Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markell file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markell?
I'm sorry, Mr. Markell's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendy Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that. And it wasn't legally supportable. in
That's
my
not a
opinion.
valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle.
Sure, and it had to
overcome.
have impacted you. In this instance, it was clear from Mr. Markell's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendy on the financial issues, February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids, or she would let them stay home from school so her parents could spend time with them, and they were little babies. And he didn't like that because he wanted to be able to go to the childcare during her parenting time so he could see them every day. And I think the childcare person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed the motion to dismiss on March 10th. to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest. And there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendy was present or not. But I would like Wendy to make it stop if it's true.
Did the grant this motion, the March 26, 2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markell request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.4 or 5, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendy to have to call him so he could watch the kids, even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. that's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markell filed?
I think it would have been similar to what Ms. Adamson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all because it was a complete waste of everyone's time and money and emotion because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert eye roll here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have. And that's one of the reasons I wanted to call Kristen because, again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendy of that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendy had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions because, like Ms. Adamson said, relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markell been able to sustain his burden of proof for that motion?
I'm sorry, say that again.
Would Mr. Markell have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. how many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markell that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Do you know how much in attorney's fees Wendy Adelson incurred, attorney's fees and costs for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
Okay. In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
May I show the witness the demonstrative?
You may.
Volume 1, Volume 2, Volume 3, Volume 4, Volume 5.
There are questions for the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
This are these 10 volumes, a example of a hotly contested relocation case.
Well, and I just count 500 pages per binder. So that looks to be about 5,000 pages. I think the actual pages were over 10,000. So this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal. So perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, it's better.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you to the jury room. You may be seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Donna Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
Just relevance, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
It's brief.
Ms. Bailey, please step down, step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach. I'm going to remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Are the jurors using the restroom?
They are.
Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
Hi, everyone. It's the COE here. Just want to let you know that Joe had to take care of some things, but she said that she will be back in the afternoon. And Tim is obviously working as well all day. So he hops in and out whenever he can. We are not on a lunch break yet. Judge Everett said that it's a quick bathroom break for everyone right now. And then the witness is going to come back. We don't know for how long, but it's obviously 12:21 p.m. Eastern time here. So we assume that at some point they would also take a lunch. But right now it is just a short, quick break. Joel, the host of the show, is back in the courtroom. He was in the media room. He goes back and forth. But he's back in the courtroom now. So if you look here at the chat, Joel is giving us some updates. And yeah, hopefully it's just going to be another few minutes. And then we're back here with the witness continuing their testimony. Thanks so much. If you're new here, please remember to hit subscribe. You can hit the like button. And if you've been here for a while, thank you so much. We appreciate you watching with us every day, all day. And again, we do have Joe, that's Law Professor Joe Patuto, returning this afternoon. And then whenever we go on a lunch break in a little bit, we will have Joel doing a lunch live from outside of the courthouse, how he usually does it. And then today, after the stream, that means after all of the testimony, Joel and best guests will do a full show with analysis. All right. Thanks so much, everyone. We appreciate you.
All rise, you're entering the courtroom.
Everyone can be seated. Please continue with your examination.
Thank you, Ryan.
Ms. Bailey, how did the Adelson-Markell divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-examine.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markell would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but.
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question.
Wow.
You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
derived.
To that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't.
Exactly.
It shouldn't have been. There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Boy, this is great. Great cross.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay. Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. But I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that we would strike.
I'll rephrase it.
Was the objection again?
Improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st.
Mm-hmm.
One was the $70,000 still due to Wendy. Jail is not a possibility in that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendy. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
if Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October and the motion that Mr. Markell filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markell amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection calls for speculation.
Overruled. The witness has provided an opinion. The state will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
I thought she did a very good job. I don't know how you in the chat feel, but I'm just astonished that this lawyer wouldn't agree to things that I think every juror is going to think is accurate. And that is what she might think is routine and not matter much. A mother or a father or a grandmother or a sister or a cousin or an aunt might think was enormously frustrating or emotionally damaging. I don't know why she refused. And Georgia asked her 3 or 4 ways, and each time she resisted and resisted. And ultimately she had to concede, but she conceded in a very, not happy way. And it made her sound as though she was an advocate for the defense as compared to an objective expert looking at the information. I also thought that to say that $80,000 is not a lot of money, I have no idea what world she lives in, but I am fairly confident at least some of the jurors would not agree with that comment. So I missed some of what she did testify to, so I don't know how well she did with the rest of the testimony that she gave, but I gather.
Redirect examination.
Briefly, Your Honor. Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day.
I mean, that was probably a good
Members of the
question.
jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
But the problem with that question and answer is that she, at least when I was here, consistently identified with Kristen, said she liked to litigate against her, relied on her factual information and mentioned her a number of times. So then to say that she wasn't influenced, I think that answer is just not as forceful as it would have been if she hadn't looked like
Everyone can be seated.
couples.
The discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
From the state, Judge.
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioning the gallery again. I don't know what steps the court, needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior, that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yes, Your Honor. Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of your witnesses are present so we do not have any continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
That's a bad answer. I'm not aware, rather than they are not, after you've had 2 violations already. All right, well, I am back. If there are any questions, I will try, but Joe is going to do the noon live in about 10 minutes. I don't know whether it's been put in the chat. I know that if you go onto the STS website, you'll find the link there. So if there's a quick question, I will take it. While I'm looking, I will. Here you go.
Joe, I have a quick question for you. Right now, what Zellman was just referring to, people commenting, and I know that we don't always see what's going on in the courtroom because the cameras are showing who's on the stand and the testimony. But how common is that? Do you think Zellman is just trying to find excuses? Do you think there's actually a lot of commentary happening back there? I mean, it appears that the person on the right-hand side or over his right
is Harvey.
Yeah, it's Harvey and his people that have been there and coming back and forth from the defense side.
It's not common. People in a courtroom tend to follow what the judge orders. They tend to be respectful of the process. It's not universal. It's not impossible that there's somebody out there who is not following the instructions. I would expect that somebody else in the gallery who might have seen and heard it would go to a bailiff and say, that's the one. And I wouldn't be surprised if that doesn't happen over the break, because the people there who are following the rules and being respectful and appreciate the fact that it's a public trial, and in our system, they have a right to be there and be witness to what's going on, would also be willing to point out someone who's breaking the rules and making it more difficult for everyone.
And going back to the witness testimony that we just heard for a while, people were, at least people here in our chat, were slightly offended, saying they really felt like there was a lot of victim blaming, and they were often surprised by the attorney's reactions and by how defensive they were. Did you find that to be the case?
Well, I was missing for part of it because I had that IT issue, so I can't comment directly on it. I was there for the first part. And, I can see how people would say it's victim bashing and it's unfair. On the other hand, look at it from the defendant's perspective. The state's case is that they were so angry with Dan Markel and so angry with the way he acted in the divorce and the post-divorce. And they're trying to combat the idea that, he was just a wonderful guy, almost a saint. And therefore, this is part of trying to show it. But I will say that this seems to me to be an amazingly inconsistent defense, because Jackie started out with that 10-minute beatification of Dan Markel. He's such a wonderful person, such a kind person, such a great father. And then you turn around and now want to say, look at how bad he was. And he was so awful that Wendy was upset and Donna was upset. That's a kind of, that's a hydra. It's a two-headed defense that it seems to me is going to lose everybody. What is your picture of him? Was he difficult in the divorce and he made things really difficult? Or was he this person that she described at the beginning who was so wonderful? You can't do both. At least I don't think you can do both. And that's what I think is happening. But the fact that they go into the documents and say, this is what he said, this is what he did, I think that's fair game because it just showed. But having said that, it not only, you can say victim bashing, but what it also shows is it emphasizes the motive, at least part of the motive to kill him. So I don't know that it helped them. I think it was difficult to hear, but I think it was fair game to reference it. I did not hear what this Linda Bailey said about it. I think even when I was here, I think she went, past her brief when she described what gibbers meant when she had no way of knowing what gibbers meant to the parties. And that's not her business as an expert. She's not an expert on linguistics. So if she was doing more of that, then I think that's a fair criticism of her.
And this question for you from Cassandra Lee asking, how does the behavior of the lawyers impact their relationship with the judge for future hearings?
It's not good. What you have as a lawyer is your reputation, both with other lawyers and with judges. And if you get a reputation of being sloppy, of being pushy, of not doing things correctly, of always trying to push over the line, there are things that both lawyers and judges can do within the rules that makes your practice harder. An opposing lawyer, when you say, gee, can I have a continuance, will say no. Go to the court and get it. To a lawyer who's perceived to be a real problem. Where with another lawyer, they're more willing to say, we'll try to go along with you and help. Same thing with the judge. The judge can make things more difficult or less difficult within the rules. So it's not a good place to be. As I said, at the end of the day, certainly in the legal community and maybe everything in life, what you have is your reputation for being fair-minded and doing a good job and doing things well and staying within the rules and not trying to take advantage. And if you lose that, you lose a lot of credibility no matter what the audience.
And Joe, the witnesses were very verbose, to say the very least. And, they went on, but the question really is, were they effective? Do you think that they were able to relay a message to the jurors today?
I think, with the caveat that I didn't hear part of Bailey's testimony, I think not, for two reasons. One, and it's the point that Georgia made, it does not matter that, this in the range of divorce and post-divorce proceedings that these lawyers know about, this one for them is not contentious, or in Linda Bailey's mind, even almost amicable. What matters is what the parties in this case felt about it. It doesn't matter. They may be unreasonable in the eyes of Linda Bailey to see it as contentious, but if that's what they felt, that's what they felt. So in that sense, I don't think the discussion of this is the way, divorces go and people then get along works. The second thing is, I think she fell apart on cross. To be unwilling to resist saying that the person who's hearing, nasty things said about her, or the person who has to go back and forth to court to try to assure that his children are not being, demonized, or he's not being demonized in front of his children. That person it's going to matter to that person a lot. And you need to admit it. And she just didn't want to admit it. She resisted and resisted. And the end result was, first, I thought she sounded a little ridiculous. And second, she sounded as though she was in the pocket of the defense. And neither of those things are a good place to be. So I don't know, COE, how you felt about it. I don't know how people in the chat felt about it. But the way I felt about it was an extraneous issue to begin with in terms of this case. And I don't think don't think she helped, but I think in some way she may have harmed the defense.
Yeah, I agree. And as you know, I have no legal background. So I'm just watching this as if I were a juror, any civilian, on jury duty who's just learning about all of this for the first time. And I really don't think that it helped them in any way. If anything, it was just very uncomfortable to watch and absorb. But I'm interested to hear what Joel will say about it and what the jurors
Yeah, I agree.
we're reacting to it because ultimately, I guess that's
Well,
what matters most.
COE, what did you think about her saying $80,000 is nothing?
I don't care where you live. I don't care how much money you have. $80,000 is a lot of money.
And it's too bad these jurors will not have in front of them Harvey's reactions to his money being spent. Because it seems to me with him, $800 would matter a lot. Maybe $80 would matter a lot. Yeah, I don't think she did a very good job at all. But I think you're right, exactly. Joel has been able to observe the jurors in the courtroom, and I think his read will be very, very, very interesting.
And speaking of which, he just called me here on the other line, Joe. So I'm going to hop over and go help him and get him ready. But we will be back here. I think they said, was it 2:15 p.m. Eastern time?
Yes.
So 1 hour and 15 minutes.
Okay.
We're going to keep this stream up as we do every day. If you guys want to go and watch Joel's lunch live, you guys can click on the link. We have it here in the chat right now. And you could also find it on the main channel here at STS. You can just click on lives and you'll see that it says lunch live. And whenever that lunch live ends, we will automatically redirect you back here so that you don't miss the court stream, which starts up again at 2:15 p.m. Eastern time.
Okay, and I'm going there right now on my phone to see it because I think he does a great job with them. So I'm going to go over and listen.
Thanks, Joe. All right, we'll see everyone there. Thanks, everyone.
So long, everyone, and we'll be back at 2:15. I'll probably be back a little earlier than that, but certainly by 2:15.
All right, two matters to briefly address before we bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Ms. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call?
The waiver is specific as to the counsel that our client received from Ms. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
This is Donna's first lawyer. If you watched the hearing after she was arrested, when she said they were keeping her in solitary and they claimed that she was ill, that's who this is. Got to take a call.
Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discuss after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Yes, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
Yeah, if I may judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yep. Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily.
I'm sorry I had to run off to take that call, but it was an important one and I knew it was coming in. So if there's anything, I'm sure there's something I missed. If you want to tell me, that would be great. And I will observe what I'm sure is obvious to all of you, that Judge Everett has had it with the defense, and he's giving them 5 more minutes to discuss with Donna whether she will testify or she won't. And here we will sit with, the proverbial bated breath, waiting to hear her decision.
And Donna, the attorneys were, sorry, Donna, Joe, Donna's attorneys were saying that they didn't have enough time. And Judge Everett is saying, apologies. Judge Everett is saying, we've given you so much time over the last couple of days, especially yesterday, that we ended early and had an additional 2 hours. Talk to me a little bit about that.
Well, clearly he is exasperated with them. He has reached even Judge Everett has reached his limit. She has a right to either testify or not testify, but at some point, the state has a right to know whether she will testify or not, because they have to be ready. They have to prepare. And she was given a lot of time to consider whether it's in her best interest to testify or not to testify. And in her case, I understand that it's a pretty tricky decision. Most defendants do not testify because they open themselves up to cross-examination, and very few defendants hold up well on cross-examination. And cross-examination allows in evidence that could not otherwise be admitted because it can be used to impeach. Donna, for example, will have to explain Vietnam, and the state will be able to impeach her on some of her claims about why she went to Vietnam that she testified to at a hearing maybe a couple of months ago. So she's got to pull the trigger on this one, or pull the ripcord on this one, and decide whether yes or no to testify. And as I say, Judge Everett has had it. He did give them extra time yesterday. We all know we ended early yesterday. I'm assuming they used part of that time to chase after the guard.
Concerning things that are said by the defense. And although the proceedings are public, that has not stopped peanut gallery from their comments and laughter. We are respectfully requesting that the court here allow Ms. Adelson to participate at Sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we are not going to do this for very long.
What in the world? Are the additional issues that people will actually see and hear her? This is the, excuse me and forgive me, those of you in the chat, because now I'm annoyed too. This is the prima donna speaking. Prima donna. I actually like that. I'm probably not the first to use it, but I like it. I mean, they know everything they're ever going to know. They've seen the state case. They've heard some of their witnesses. They know, who else they intend to call. There is nothing else out there that they need to know to make this decision.
So is this just a strategy to delay, a strategy to somehow try to throw off the state, or what would be the purpose of this?
Well, delay doesn't make any sense to me, because delaying the inevitable still means the inevitable is going to arrive. If they're trying to track down that, that jail guard that they say they couldn't find and they want a judge ever to subpoena. Remember how they started out this morning? I suppose that might be something, but it doesn't delay. I mean, the fact that she hasn't decided doesn't mean that that they can avoid their obligation to put on their defense. They're still going to have to put on witnesses this afternoon. And if they've got other witnesses, they're going to have to put them on tomorrow. So I don't know what the delay would be. Again, it may be strategy in that they think, they can put her on and it will be, the state won't have a chance. Georgia will not have a chance to prepare. And if, and if they're not going to put her on and they delay it, Georgia will have to spend a fair amount of time preparing for a cross that may never happen. So that might be the strategy. It's, I don't know. But clearly they've got a judge who has had it with them up the kazoo. And they've got two prosecutors who also have had it up the kazoo.
And excuse my ignorance, Joe, but they said that they've had no time to go over the evidence. I mean, didn't we all know this was happening?
Well, the point is, this happens to every defendant in every trial. I mean, trials go. The state puts on witnesses. The defense has to decide whether to put the defendant on the stand. There's nothing that I can see that's the least bit unique about this trial and this case. I mean, they knew from discovery, from the depositions they did, and from the other trials, most of what the state was going to put on. In fact, compared to other trials, they have a lot more information on which to decide what they're doing. So I don't think what they're saying holds a lot of water.
And at this point, would it benefit the defense for Donna to testify?
No, but they may have to. Somebody has to explain, the one-way ticket to Vietnam and the scurrying around and trying to get, the wheel in order, and trying to do this on a rush, all of that. And her friends who testified tried to deal with the one-way ticket part, but they couldn't deal with the rest of it. Now, the defense may feel that's enough because there's nothing she can do to help, and all she can do is make it worse. But somebody also has to address the information with regard to the two informers. And they may again feel that they got enough by all of us watching that video. And if they did, I don't know what they're thinking, because I thought that video helped the state more than it helped the defense. So, CEO, there is no explanation for this. They should be ready, they should know, and they should have made a decision. And meanwhile, if I had known this is the way this trial would have gone, I would have timed every time we did a sidebar, or the defense needed time for something, or we had to have an argument on the record in the court. And I would have just had a record of how much time we have spent on this trial. where nothing's happening. And he complained again about the gallery. I wish Joel were, is Joel in the courtroom now?
I believe he is, but the interesting part is that Joel has said that he hasn't really noticed throughout the whole trial, he hasn't really noticed a lot of people, talking or overreacting or any of that. I don't really think anyone else has mentioned that either.
So do you, I wonder whether Josh Selman is really either not being truthful or exaggerating what's happening. Because that's something I think they might try to do strategically, to say the courtroom has to be cleared when Donna's testifying because the gallery has not been able to control itself. And Donna doesn't want to testify in front of people in the gallery. Now, if it's over her right shoulder, that's her husband. He should be able to report who it is that's doing it, if anyone is. So, and here we are still discussing this.
And someone else here in the chat is saying they're sure that a bailiff would probably notice it as well, or someone else in the court would, flag them and complain and pull them aside.
Exactly. And I wonder why the Judge Everett just doesn't call all the bailiffs and inquire of them specifically. Have they noticed anyone who's making any noise or, talking or anything else? I mean, it is a little unusual. It is unusual for the defense lawyers to go to the judge and say, we need your help to decide whether our client is going to testify.
You can bring in the juries.
Okay, we'll find out what the decision was, maybe. My guess is they're saying they need to talk to that guard to make the decision. If I had to guess, what's happening, that would be my guess. But it's their fault if they haven't been able to reach that guard until now.
All rise. We're entering the courtroom.
So we have not been told what the decision is. Is this Descalzo? She was the first lawyer that Donna had at that first hearing when Donna said she was on a suicide watch. And it was
We had a restful lunch break.
unnecessary.
We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you.
Descalzo is not a criminal lawyer, and that was obvious from
One time the
the
defense would call Marisol Descalzo.
first hearing. She talked about extraditing Donna from one place in Florida to Tallahassee, which obviously is not, you don't extradite from within a state.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney.
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call ethics counsel and call the Florida bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson. So I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
At the hearing, when Donna was in solitary, this lawyer argued that there was no evidence that she needed to be in solitary, that she had a mental state.
Joe, I heard your comment. She is a criminal lawyer. She does federal white collar.
Now, if someone has a warrant, is
I
it
heard
up
her say
to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But So it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure.
She
Why
should have
was she
Baker-acted
suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay.
That's a lie.
Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you.
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overall, the witness has opined on this matter.
I'm not law enforcement, so I'm not sure. And I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
okay.
Would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Joe, I got to say, this really bothers me. She says that she called the prosecutor to see if she had a warrant and before the verdict, And now she says, no, she wasn't thinking about herself. She was only thinking about going on vacation.
I know.
That is outright not believable.
Specifically, though, about self-surrender. Would you expect that to change law enforcement stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr.
Donna
Scott,
definitely is not going to testify.
prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
But of course, that's not something Donna might know.
Called for any purpose.
Well, we know Dan doesn't know it.
Might be like
This woman didn't talk about it, so
Yeah.
Donna wouldn't have known.
Released. Please call your next witness.
You said you were bothered about, what
I
she
just-
said pre-arrest. I am bothered that at that hearing, Donna was in jail in solitary. She
Right.
got up and said there was no reason, no reason to keep her in solitary, that they were overstating the self-harm issues.
That's right. And that's,
I wish they'd crossed on that.
I don't know why these witnesses, why lawyers would go into a courtroom under oath, jeopardize their bar license, and say things that are just so contradictory to the evidence and
Yeah,
their
but
earlier positions. I don't
Yeah.
understand it.
Yeah. But I'm sorry that Sarah Catherine didn't ask her about that, because that was the position at that hearing.
Right.
And that was right after the arrest. It's not as though there's a big time gap.
So Joe, what they're doing everything they can to fill the gap so Donna does not have to testify. They don't want to tell the judge she's not testifying because they want to wait to the last minute and say we rest, so the state won't have time to get their rebuttal witnesses.
Right.
Because they certainly know if Donna's testifying by now.
Well, I am inclined to believe that Judge Everett will give the state some time to get the rebuttal witnesses
Raise your
in.
right hand down.
Sure.
You swear or affirm the testimony you're about to give will be the truth.
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay. And is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I move into evidence defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that objection.
A lot of qualifications.
Well, there's just
Members of the jury, we're going to take a brief break.
Oh, God. I hope they do a rebuttal and bring in somebody from that initial hearing.
That would be great if they would bring someone from the initial hearing where she testified, trying to get her bond, right?
Right.
Saying her mentally, she's perfectly fine.
Or if not bond, out of solitary. She didn't need to be in solitary because they were
Right.
overstating the mental situation, and in the prior
You can
holding,
just say that
she wasn't kept in solitary, whatever they call solitary these days.
Right.
if anyone needs to stretch their legs or use the restroom, please do it now.
So George is listening to the tape that they want to introduce. It appears. So the jury just gets back from lunch and now they're out back in the jury room. I'd like to hear what they think about all the ins and outs and delays. So she didn't say she was a defense lawyer,
She is.
but didn't you hear the question?
Oh, not this one. This woman's not a defense lawyer.
Oh,
She's
no,
a
not
victim
her. I
witness.
thought they asked Mayor. I asked the.
Marisol said she does criminal defense. She just
Okay.
didn't know what extradition meant.
Yeah.
Now she's saying she's an expert on extradition, even though she didn't know what it meant
Right.
at the court date.
Right. I remember at that hearing, the judge was very kind to explain to her that it wasn't extradition she was talking about. For those of you who haven't heard that hearing, you can find it if you're curious. So Tim, do you think they have enough to cover Vietnam and
No.
the informers?
I do not, but I think what they're doing at this point, they're trying to hope.
Wendy Adelson saying this is the worst day of my life before the call connects. And then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now. So subject to those objections, no objection to the exhibit once those things are removed.
Mr. Zeller?
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back in the jurors.
What about Charlie, Tim? Do you think Charlie's going to testify?
No, I think what they're doing, I think they're playing cat and mouse with the judge because they don't want the state to be ready. They're getting everything they can in. You see them introducing their exhibits now. They're
Right.
finishing up and they're going to rest because I think they believe they'd rather go to the jury with just a conspiracy charge. They're going to renew their 29 motion, preserve that for appeal, hope the judge grants it on the first degree, and then take their chances in argument with the conspiracy charge. That's my guess. That's what it looks like.
We'll see. Thank you.
All rise, you're entering the courtroom.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No,
Have you ever met her?
no,
So you don't know what her normal demeanor is like?
correct, I don't.
Okay. But Wendy Adelson, her daughter, presumably does know.
Correct.
Do you remember Wendy Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay,
No further questions.
redirect.
Your Honor, we'll just strike the question from Ms. Kappelman.
Members of the jury, you are to disregard the last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
Is this their last witness? Are they going to announce their arrest?
Exhibit do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. The bailiff will take you to the jury's room once again. Everyone can be seated.
They got all the witnesses that they
Please
said
make
this
all
morning.
necessary redactions and changes at this time.
That they were going to call this morning.
Joel, do you know what we're doing here now?
He's making the edits to the call to take out the comment, the two comments.
Okay.
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation concerning this.
I am capable of seeing that, Mr. Zellman. No narration is needed.
Come on, Donna. If there's this much consternation, I don't see her taking the stand.
Mm-hmm.
I don't see a big notebook in front of them to walk her through her testimony either.
Mrs. Kappelman, once the defense rests, is the state intending to place or put on any rebuttal case?
I think not, if they rest without calling any further witnesses. that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise.
She's not testifying.
You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
Oh my God.
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
Did I understand that correctly?
Anyone in the gallery needs to use the restroom or stretch your legs. This is your opportunity at this point.
He needs 5 minutes to decide whether he needs time. Is that what he said?
He needs 5 minutes so he can talk to her, because
Oh.
Jackie talking to her is not enough. And she's still conniving. She's still trying to work the system, just like her whole life, trying to find a way. And the judge is not putting up with it. This defense lawyers know that they've told her not to do it. So it doesn't surprise me.
I thought her relationship with Jackie was closer than it was with Zellman.
Well, obviously Zellman thinks he can talk to her again. They're
Okay.
buying 5 minutes.
They got 5 minutes before.
I know. This is we're gonna find out. It's par for the course for this defense.
That's true.
So we'll see. I
And
expect
are the jurors seeing this?
no, they're out of the court.
Oh, okay.
They
Okay,
do it
just
outside
making
the
sure.
courtroom. And if she doesn't testify, then the court will put it on the record before the jury gets in, and then they'll rest. So not surprising, unfortunately. I predicted this.
Yeah. What does she, I mean, she can be a drama queen if she wants, but I don't see what she thinks she's going to achieve by not being able to decide.
Hey, Joe, just so you know, I'm heading out for my carpool runs, but Space Coast is here behind the scenes if you need him for anything.
Okay.
All right.
Thank
Thanks.
you.
Thank you.
Well, I think Tim is right. She's going to say no, but I wish she would say yes. Megan wants to know what her end game is. You got me. Can it be an appellate issue with the judge making her decide? No, I mean, she has to decide. We can't live with this trial until, Christmas or, the new year. And she's had plenty of time. They should have talked about this before the trial started. At least some of the, the consequences and the pluses and minuses. He gave them yesterday afternoon to talk to her. I don't think I've ever seen this before. Is it 5 minutes yet? I feel like a child in the back of a car.
Mrs. Elman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Edison, the question remains. As it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Didn't say that, Judge. May I have a moment to confer with the counsel?
Go ahead.
I think she is going to have rebuttal.
I wish she would.
I think she's going to find the transcript of Descalzo very illuminating. Interesting.
Have you ever seen this happen with a defendant before?
Never.
Nick, that's what I thought. That's what I said. Neither have I.
Never. I think she read my article. That's why she didn't want to testify. Right. I sent it to you, Joe. Did you get the?
I did read it. It was very good. Thank you.
So, Windsor, Georgie. Sorry.
Now what? She certainly doesn't need to talk to defense counsel to decide whether she's calling rebuttal witnesses.
There is one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now. I can find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
What a surprise.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. I will give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, the counsel have a moment to confer concerning whether or not we are going to rest at this point.
Oh, for heaven's sakes.
Call.
What we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
So, Tim, they haven't decided whether they've rested yet.
So, Joe, what are we doing now?
They have to decide whether they've rested or not.
They still haven't decided that
They
yet.
haven't decided. They may have a witness they want to call.
Yeah. I wonder who the next witness is. Who haven't they called?
On their list,
Remember they said they needed like 5 to 6 days?
they haven't called Susan Brotman, the estate lawyer who was there the
Yeah.
day of the drop call. They haven't called Lisa Carey, the other real estate agent. They haven't called Tara Kawas. Then we've got state witnesses who've testified. They haven't called Yindra Mascara or Jessica Rodriguez. And
Oh, they haven't called Charlie.
They haven't called. Well, I knew you knew that. I mean, you didn't have me to tell you that they hadn't called him. He was still out there. But that's the list.
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualified or hearsay exceptions. The state's indicated that they're objecting. If I could just have a moment.
Not the confident look.
No. Maybe she'll wave her hand at the judge and say she changed her mind.
I was just thinking the same thing. If this goes till 5, she'll come back tomorrow and say, Judge, I think I do want to testify. And you know what? The judge would probably have to let her testify.
I think he'd have to. Talk
Yeah.
about a potential appealable issue.
Right.
But that would get her what she wanted. She'd have a chance to talk to her lawyer some more.
You know, I just saw the way they were presenting this case, that they were doing everything not to call Donna, not to answer these questions, tried to use smoke and mirrors to try to address a lot of these issues, but they haven't. There's so many issues. The state has so many issues to hit them. The day planner, the code, the bump, you know, things like that. It just.
The consciousness of guilt with regard to her vacation.
Yeah, that no one's buying the vacation. Nobody.
Gentlemen, concerning the items, we do need to move on so a ruling can be made.
Just not prepared. They're just not prepared. Oh, I think Donna does want to get up there, and I think 3 people, well, 2 lawyers and a paralegal, are telling her no. It's going to be bad. And she's probably thinking to myself, really? I'm listening to these people? But that's what the lawyers are there. She hired them. She's riding with them. She has to trust their judgment.
Oh, I know. She hired them. She's riding with them, but she sat through this trial, and I don't think she has to trust their judgment.
I don't disagree with that, Professor.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is, I believe it's states 51. No.
These calendars who show how meticulous in detail and how in control she was over everything, these are what they want to introduce?
Well, they must have found something in one of the calendars they think they can argue, and they're trying to sneak it in and think the government won't object. That you would never introduce a calendar if you didn't think there was something positive in it, right? Yeah, Jackie hasn't done much the last day or 2.
So do you think the jury will react at least with suspicion if they introduce the calendars and they've never discussed the calendars?
Concerning these items was the state's argument.
State's objection is hearsay, Your Honor, and the portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents, and the state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023, where my client lists those very same items to get prices to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by.
believe as in the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, What witness testified concerning that?
No one.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was...
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witnesses laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
He's begging now. He's begging.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research. But again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just one.
I know one witness who can give them foundation.
Yeah, she's sitting there with her. I don't believe he's going to let it in. He was right. Recordings are different because recordings could put it in context.
Right.
Where a notepad, you could have a bunch of hearsay and self-serving and not testify. That's the way to get around it, right?
Yeah.
Judge was right on top of it.
The judge is very exasperated.
He is.
He's had it. He's had it. He had it. He was up to his forehead with this several days ago.
The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, that has been admitted so far in this trial, is the page that shows
The license plate number.
license plate number, sir. And so I don't see how birthday party planning
Is relevant.
adds to the completeness.
Yeah, I agree with her.
Addressing the license plate numbers, I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 22 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 at 7:06.
Please leave them with the clerk.
Judge, if your honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Wow. Well,
State has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct.
Yep. Jurors are fine to come in.
he's right on top of it. He really is.
Yeah.
Oh, the paralegal's doing her job.
What's her job? She patting Donna again?
Yeah, she's consoling her.
Courtroom.
Wait till the jury hears she's not going to testify.
Mm-hmm.
Everyone can be seated. Defense may call its next witness.
Defense rests.
All right, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties. And from there, tomorrow, you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
I interpret, or at least attempt to be a dig at the defense lawyers.
Now they're going to make their Rule 29 motion again.
Yeah.
Everyone can be seated.
Of course, I don't think anything the defense put in
Please
changed.
open your copies of the jury instructions.
Right.
My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
So they have less than a day and a half witnesses.
3.2, Statement of the Charge. Any requests or changes?
Nothing to say. Your Honor, the only request that I would make is that the name of my client and the names of the charges not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note. Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
Yes, sir.
As to the next paragraph concerning lesser included, Is the defense asking for all category 1 lesser included?
What are they doing?
They're going through the jury instructions.
No, I know, but we paused while they're considering whether the lessers of murder 1 should be, jury should get them in the instructions.
What do they always do?
Being approved by reply, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well? It's category 1.
With the although it's a category 1 lesser, it still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a category 1 lesser?
Yes, sir, we'd be requesting all lessers.
Who's doing that
All
for the
category
state?
1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes
I
the
can't
lesser
see.
crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful.
I don't see what in
I
the
believe the
evidence.
indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform the indictment, we would request his full name, Your Honor.
Acceptable to that.
If you find Daniel Markel was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as I'm party requesting.
Just a moment, Your Honor. I would agree with the court's conclusion there, Your Honor.
Mr. Evans, Ms. Koppelman.
Oh, it's Eddie Evans. Eddie Evans is the,
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markell is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation. That will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
No, sir.
All right, 7.4, second degree murder. Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
So they had him here, so they were prepared for this.
Yeah, so she's working on her clothes.
Second definition, an act is eminently dangerous to another and demonstrating a depraved mind. That must be given.
And Eddie is good.
In order to convict of second degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markell is dead. As to element 2, which theory is the state proceeding on? Well,
Yes, the defense rest.
somebody B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markell, or Donna Adelson intentionally procured an act that caused the death of Daniel Markell. Right. Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markell was not excusable or justified.
Zellman didn't need to be heard concerning the concession that it's not excusable or justified.
Not in the facts of this case, Your Honor.
And defendant agree with that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide is justifiable or excusable?
I do.
And as to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
Please discuss it with them now.
Thank you.
This is interesting that
Mrs. Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that.
You are giving your consent to this.
I am.
They're consulting
To
with the
move on
defense.
at this point, the paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard? In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
There you go.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested. I believe as to the first paragraph where it says attempted homicide cases.
We're not background. Just for the completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for.
Correct.
Completed offenses.
I believe that instruction must be given for first-degree premeditated murder. And all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markell occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markell.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
You have to intend the act, but you don't have to intend to kill him.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor. Not sure that manslaughter is included in that, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
It's fine.
And so you can contact me on that, Judge, and I'll let you know at the latest meeting.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as a second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those? For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I excuse me, I moved down the principles already for next time. So I ask yes or no. There's no evidence that the defendant in this case actually possessed a firearm, so no, we're not requesting.
It will be removed. (3.5) sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proved beyond a reasonable doubt. Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say that again?
Element 3, the bracketed portion, it says crime or attempt. The crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe it. I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I think this crime is the appropriate one given the standard judge.
I'm going to look at the standard briefly, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, yeah.
I would ask that the individuals, Secretary Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and/or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction.
3.5 sub B, element 3.
Yes, sir, but I'm saying for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, I believe the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
My reading This is the new instruction.
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state. In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanawa, and or other persons to cause the first-degree murder to be committed, either by them or one of them, or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanawa and or other persons. So I think it could be.
You're just requesting an and or between the names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury, and we would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding and or are, it can include, basically, if you put something or, I mean, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanawa or other persons, that would be acceptable to say.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine McBanawa or other persons. It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. Then lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I'm not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
Legally, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanois, and or other persons to commit first-degree murder. As to this, the party's asking this to read with the same or that it does for conspiracy to commit.
Yes.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All 4.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area,
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they previously been defined. Or do we need to?
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter, whether it can be argued that someone is a principal and solicitor.
Thank you.
Principle is the
For
example.
now, I will just move the 2 instructions to the end of the counts.
The quarterback, the receiver, the captain.
Just needs to clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
And they're also not
I can
any,
add it, but ultimately, no instruction can be argued as to defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
they're knocking out extraneous stuff that in the standard instruction shouldn't be given, such as justifiable homicide. There's no evidence in the record that what happened was justifiable. In order for that to have stayed in, there had to be something in the record from which one could argue that the killing was justifiable, self-defense, for example, and there's no evidence whatsoever. So that's the kind of thing they're knocking out. And this is all important because this
Just add at the bottom the principal theory.
we'll use to decide whether the state proved its case beyond a reasonable doubt. They have to match
This
the evidence.
instruction does not apply to. Now do that for both principal instructions.
They have to match the evidence to each element as the element is defined to them by the judge.
All right, moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
Basis is not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given.
Standard instructions are those that have been approved by the Supreme
3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
And they're the starting point.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
The advantage of a standard instruction is it's already been vetted by the Supreme Court of the state, and so there's no viable.
Number 10 is on or not, but it's a 6, 7, 8, and 9.
No viable challenge.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Newly tailored instructions can be challenged.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony?
And as Judge
Or
Everett
misdemeanor involving dishonesty?
said, the instruction that the defense objected to, he's used in murder trials before, including Charlie. So
Whether the
it's
state
already,
has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony.
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you, would you like to?
Yes.
Copy to the defense. Sorry about the typo in the title
And
and the certificate of service.
Special instructions or tailored ones become as good as a standard once they've been used and
As
changed.
to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
And approved by the Supreme Court. And the one that the defense objected to, Judge Everett has used several times. I don't know that the Supreme Court has ever ruled on it, but it's got some cred attached to it because it's been used several times. And they're going to have to get the instruction done
I have an
on.
objection to the first one, but the second one we do.
What is the objection to the second?
On Linda Bailey.
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at Sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it's just dawned on me where you're sticking the previous requested instruction that the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now.
At 4:30, Joel's doing his recap show. There'll be a link in the channel if you want to go over to hear the recap of the day. I'm not sure whether there will be a link here that will take you right in. The COE is not back yet, so I don't know if that
Going
will.
back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested.
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
Show at 4:30 is substituting for the 5:30. It's just going early, than usual.
For the record, as I understand it, of the bracketed languages under accomplices and informants,
Who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
all right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That is be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness that will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
There you go.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
There you are.
Cautionary instruction, does either party wish to be heard?
No, sir.
There you are.
Single defendant, multiple counts, does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count one, we the jury finds as follows as to count one of the indictment, first degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first degree murder. Option B, defendant is guilty of the lesser included offense of second degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count one. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is the raise?
The only thing I would suggest, if we leave them involved, it makes it clearer for the jury to differentiate between each of the counts, but I'm real strong in it, but I see why they would be involved.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we, the jury, finds as follows as the count 2 of the indictment: conspiracy to commit murder. Check, only one letter choice as to this count.
This is the verdict sheet.
For the guilty, not guilty words in count 1.
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
Remember the issue that came up in
Same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
Okay. I'm moving off to go for a few minutes. The link will be up and you can move over.
And when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think.
And I don't know how long this will stay up. I couldn't get an answer for you. So long.
The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C. So it's not up under the check box. But other than that, I think throughout the verdict form, we're going to be asking the same thing. Leave it as is, because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, we'll grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
We suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages. All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't tell me too much.
Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, all the exhibits.
A demonstrative is not admitted, so yes, I would agree. It does not go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before they're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter. It is not necessary for the state to prove the defendant intended the death of Daniel Markell. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right, once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
Hey, what's up, everybody? If you can hear me, we are going to start the wrap-up show on another link, Space Coast. Can we redirect everyone? This looks like it's ending anyway, so I'm going to pop out of here, everyone. The COE is stuck in a storm, and I'm going to start the wrap-up show with Joe, Jared, and Ashley, and I think Tim is going to bounce in as well at some point. So going to be starting the wrap-up show momentarily. And Spacey, I'm hoping you can redirect everybody to the next link. See you guys in a bit.